case I was involved in involved a 92-year-old lady who was coming under significant pressure from both her neighbour and later family members to transfer significant amounts of funds from her own bank account to their bank account. Her overall assets would amount to in and around £250,000. So there were significant changes being sought in terms of gifts within the will to the person who was presenting her into the office and his family. And in another instance, there were direct attempts to actually effect electronic transfers from her account to another person's account in the sum of £90,000. So there were significant amounts of money involved, yes. In relation to the neighbour, he was trying to bring, I felt, undue pressure to bear on his neighbour to change her will, which had been a fairly long-standing will. He was trying to get very significant changes to make significant gifts to him and to his wife and also to other members of his family. And that, of course, was a matter which caused me to be very concerned about the validity of the elderly person's purported wish to do that. So I hadn't ever been aware of safeguarding or a vulnerable adult team or anything like that. Any of the training that we received as solicitors, generally speaking, would focus on our ability to identify when we think someone may be coming under duress to change a will or something like that. But we weren't at any stage informed of outside agencies, I suppose, other than the police maybe, who would take an interest in our concerns in that way. In fact, I'd contacted the Law Society for advice, and they hadn't mentioned contacting the vulnerable adult team at all. The overall outcome of the client is that she now is not coming under that pressure, because the enduring power of attorney that she signed when she herself began to get worried about this has now been registered with the High Court on foot of the actions taken by the vulnerable adult team. And the persons who were attempting to remove her funds now know that their efforts are useless and that it won't affect any change of funds. The banks will not release funds to anyone other than with my consent. Yes, I have, but not in this context. I would do a fair bit of criminal law, and that's a phrase which we would use quite often in dealing with people who are accused of criminal offences who may have their own difficulties, but not in terms of an elderly person. Yes, it did. It ultimately resolved itself and assisted me greatly, first of all in referring me to the police officers who were specialised in that field, and also it resulted in the client being assessed as being vulnerable and not able to deal with her financial affairs. That then allowed me to shut down efforts that were being made by others to move her finances, or not inconsiderable finances, purportedly upon her wishes. Because that's the difficulty that we had. All of these transactions were being done in her presence, as if she was lending her authority to them. The main challenge with it is that you're dealing with a client who doesn't want to admit to the fact that she's being abused or manipulated and wants to maintain the relationship with the abuser. So that leaves you in a very difficult position when you're contacting outside agencies, particularly the police. The first question to be asked is, well, how do you know she's being influenced, or has she complained about it? And in this case, she hadn't complained about it directly, but it was just that the actions, I felt, spoke for themselves in terms of the attempts to move large amounts of funds from her account. And solicitors are creatures of instruction. They're supposed to do what our clients want. And when we have a client who is saying on the face of it they want to do something, they want to assist in the transfer of money, or they want to change their will, it's very difficult for a solicitor to act on their gut instinct and not do that. Because in this case, the first thing that I was called to task with was one of the persons who was trying to effect a change in the will threatened to report me to my professional body, the Law Society, in that I wasn't acting on my client's instructions. And on the face of it, I wasn't, because I had a concern that her instructions weren't genuinely motivated. And I felt that she was coming with duress to present herself in in the office as someone who wanted to change the will. Well, I think that what would have helped is, first of all, had I been aware of the vulnerable adult team. I'm sure there are efforts being made to make others or make various agencies aware of their existence. But certainly I wasn't. That may have been my own fault, but I hadn't received any training or notifications from the Law Society or anything like that in relation to the existence of the vulnerable adult team. And I think that that's maybe something which should be looked at. That certainly as a profession we need more training about these sorts of issues, and more importantly who to go to when we have a concern which, you know, from a day-to-day perspective, it's quite difficult to set aside that sort of time to deal with your concern when the client isn't actually saying to you, I'm worried about this.